Yes, Mr. Cullen.
My lady, my lords, could I just start with a quick housekeeping matter? My learned friend and I agreed we're to split our time equally.
Yes.
To enable calibration of the chess clock. Could we ask what time the court is intending to sit until?
Well, I think we'll, at the moment, depending on how we go, we'll sit till 2 o'clock. 6 or 1 o'clock, come back at 2 and rise at 4:15.
4:15, I'm grateful, my lady.
I've got appointments over the short adjournment, and probably we've all got commitments, I think, after around 4:15. Will that be sufficient for you both?
For my part, I think, my lady,
Good.
yes.
Very good. Allowing time for a reply.
Yes, my lady, yes. So, my lady, what I'm going to do is look at the claim and the agreements upon which it's based, then consider the relevant legal principles and explain why it can't succeed, and then consider the judgment below and what the deputy judge got wrong, we say.
By the time you got before the learned deputy, you had discarded several of your points. You were down to 2, and before us you're down to 1, is that right?
That's right, my lady, yes. And the 1 may be characterised as the at the expense of point. So, my lady, with that introduction then, as I say, to look at the claim, it's important to focus on what it is that's actually said. I think one can start with the particulars of claim, which is behind tab 6 in the core bundle. And it's very shortly expressed, starting at page 80 in the bundle, paragraph 39. The Fourth and Fifth Defendants benefited from and were enriched by the purported license and the exploitation of that license for commercial purposes. And they were enriched, this is letter B, at page 81, by the matters pleaded previously without seeking or obtaining the claimant's permission. And those benefits, enrichments pleaded in the preceding paragraphs were at the claimant's direct expense, or were obtained as part of coordinated or closely related transactions between the claimant, the defendant, the first defendant, the second defendant, and the fourth and fifth defendants. And then I don't think the other bits of the claim matter for today's purposes, because they go to the unjust factor, as it were, with which the court isn't concerned today. So, my lady, my lords, that's the way the claim is put. And to understand the claim, it's necessary to look at the agreement or agreements which are said to found the claimant's rights, which form the basis of the claim. And those can be found in the supplementary bundle. And it's essentially 2 agreements entered into the same day. The first is the main agreement and the second is the letter agreement.
We don't need to look at the 1976 agreement, do we?
I don't think so, my lady, no. Behind tab 2, one finds the main agreement, which is the agreement whereby Mr. Cushing was to provide his services to the claimant for the purpose of making the programme, as it's called, the television movie, A Heritage of Horror. And one can see that at recital A on page 17. The engagement is set out, particularly in paragraph, as the clauses 2, Tyburn engages, and the lender hereby agrees to provide the services of the artist to play the role in the programme. And then 3, Tyburn should be entitled to the exclusive services of the artist during the following periods, and that sets out the periods. I don't think we need to get too concerned with the detail of that.
So the agreement is limited to Heritage of Horror.
Indeed.
But the letter agreement isn't.
Indeed. Well, it is in some respects, but not
the bit we're going to be concentrating on.
Indeed, my lady, yes. Now, perhaps before we move out of the main agreement, it's relevant to look at clause 17, just because that is the one that's, as it were, varied or supplemented by what we'll come to. And that's a clause dealing with if the artist is prevented from rendering the artist's services, etc. And essentially, the engagement can be prolonged for a period of not exceeding various lengths of time. Now, then one comes to the letter agreement entered into at the same time.
Sorry, just give me a moment. I haven't concentrated on 17. If the artist... And we need 17 because...
We
that
need
is
17. We don't really need 17, my lady, that's what
Oh,
I'm
I see,
stating.
it's
But
because
it's
it's got the
relevant
heading
because
of-
when one comes to the letter agreement,
Yep.
at page 34, your ladyship will know the reasons why it was entered into, and it's explained in the letter itself, because of Mr. Cushing's illness.
Yes.
And what it provides relevantly, in particular, at letter E, as a result of this is a variation or supplement to clause 8, as a result of the illness, the service company, Mr. Cushing, undertake, in effect, that the claimant can use certain techniques, including the use of doubles, including the use of extracts from other films, and including CGI, to supplement, complement, or facilitate the completion of the performance in the film. And then one gets to the key provision, and it's under the heading Clause 17, at letter H. If as a result of the illness, Mr. Cushing's demise, or any other reason, without limitation whatsoever or howsoever, the TVM is not produced and or completed and or exploited, PCP and Mr. Cushing by warrant undertake and agree that neither of them will permit Mr. Cushing's participation in any film programme whereby Mr. Cushing appears either in whole or in part, other than in person, in or out of any character, by way of Mr. Cushing being reproduced by all or any combination of the processes or techniques referred to in the preceding paragraph that I showed the court, without our express prior written consent, which consent we may grant or withhold at our sole and absolute discretion. Now, that's the key provision that the court has to bear in mind. Now, there are a number of striking things about it. It is, on the face of it, a rather surprising clause. It's premised on the basis that the programme isn't made. So it only bites when, as it were, the project has failed. It is purely restrictive and doesn't, on the face of it, protect any commercial interest of the claimant. And the court won't be surprised to know that there are issues in the case if it goes further in relation to restraint of trade.
Sorry, on the face of it, not protecting any...
Commercial interest of the claimant. Now, the claimants throughout characterise this as a right of first resurrection, as it's put. It said that this confers on the claimant a right to be the first to resurrect Mr. Cushing. Now, it's not a question of dealing with some difficult point of construction to say that that's simply not what it does at all, for two reasons. First of all, there's nothing in the agreements that would have prevented Mr. Cushing or his service company having already granted such rights elsewhere, or indeed granting such rights immediately after the date of the letter agreement, but before the production came to an end.
Hold on. Sorry, nothing to prevent Mr. Cushing...
Having previously granted, to use my learned friend's language, the right of resurrection elsewhere, or granting it after the date of this agreement, but before the abandonment of the production.
Mm-hmm. Yes?
But secondly, my lady, more fundamentally, it doesn't grant any rights of resurrection to the claimants at all. The only positive rights the claimant obtained were in relation to the programme, capital P. And
That's in the main agreement.
that's in the main agreement. And letter H only comes into play when that's off the table. And this clause only comes into play when that's off the table. And at that point, the claimant under this clause and nowhere else under any agreement has no right to resurrect Mr. Cushing at all. All it has is the contractual right to stop Mr. Cushing permitting others to resurrect. So, for example, if the claimants wanted to resurrect Mr. Cushing in a way which engaged any protectable rights of the estate, it would have needed to go to the estate and negotiate a license. and presumably pay a fee. Moreover, it's got nothing to do with first resurrection, because on the face of it, this right to block the use of Mr. Cushing's image, etc., and CGI techniques and the like, this right continues in perpetuity. Any time the estate wants to grant such rights to anyone, on the face of it, it requires the consent of the claimants. So it's not a right, it's not about first resurrection, it's about resurrection for all time in any circumstances. But, my lady, my lords, however one characterises this, it is nothing more nor less than a contractual right. There's no property right involved here. It is simply a contractual restriction on Mr. Cushing and, through him, his estate. Now, I will come in a moment to the detail of the legal principles to be applied here, but we say, stepping back, this is a very bizarre claim. The position is, the claim is, amounts to saying that where B contracts with A that he will not do an act, if B deals with C in such a way as to breach that, then A has a restitutionary claim against C. We say that is unheard of, and there is no case that comes within a million miles of it, and certainly no case that is cited by C in this court. There is an orthodox way for a claimant to bring a claim in such circumstances, and that is to sue B for breach of contract, and, if the facts will support it, to sue C for inducing or procuring that breach of contract, or possibly causing loss by unlawful means or various other economic torts, all of which come with their own panoply of ingredients, requirements as to notice of the relevant contract, and having the relevant intent and the like. Those ingredients have been rehearsed in the authorities on many occasions. In the authorities bundle, there is OBG and Allen, which is obviously the case in that context. Now, if the claimant's right, all of that learning can effectively be consigned to the bin, because a claimant will not need to establish those criteria, will not need to prove loss. It will simply have a restitutionary claim against the third party. Moreover, such a restitutionary claim would apparently be available in circumstances where restitutionary damages would not be. My lady, in the bundle, we also have the case of one step from the Supreme Court. I don't think it's necessary to turn it up at this stage.
I'm not familiar with it.
Well, it sets out the principles upon which one can recover either damages or restitutionary claims for breaches of contract. Perhaps we should turn it up.
Well, I'm sure my lords are ahead of me, but I wouldn't mind having a quick look if it's relevant at all.
It appears in the authorities bundle behind tab 15.
Yes.
And it's a case involving a breach of a restrictive covenant in relation to competition and non-solicitation of clients. And the question was, on what basis do damages fall to be assessed, and whether a claimant is entitled to, as it were, restitutionary damages, or whether it has to establish loss. And there's a long discussion of it, but the essential principles are set out at paragraph 95 of Lord Reed's judgment. And he there sets out cases where user damages, as they're called, i.e. the value of the use wrongfully made of property, which are available for invasion of rights to tangible, this is subparagraph 1, tangible, movable or immovable property. And then under subparagraph 2, they're available on a similar basis for infringement of intellectual property rights. And then there's discussion of damages in lieu of injunctions. But then picking it up at 6, common law damages for breach of contract are intended to compensate the claimant for loss of damages resulting from non-performance of the obligation in question. They're therefore normally based on the difference between the effective performance and non-performance. And that's the key. In any case, at common law, to recover damages, one has to establish loss. And 9, where the claimant's interest in the performance of contract is purely economic and he cannot establish that any economic loss has resulted from its breach, the normal inference is that he's not suffered any loss. In that event, he cannot be awarded more than nominal damages. Negotiating damages, that's to say, as it were, a reasonable license fee for accommodating the breach, can be awarded for breach of contract where the loss suffered by the claimant is appropriately measured by reference to the economic value of the right which is being breached, considered an asset. That may be the position where the breach of contract results in loss of a valuable asset. The rationale in the claimant is that the claimant has in substance been deprived of a valuable asset. So one can have negotiating damages in certain circumstances, but the point is they are damages for loss. Now, to come back to this case, the claimant would not have a restitutionary claim against the first and second defendants, the executors, and indeed...
Claim for damages based upon restitutionary measure.
I'm sorry.
You mean a claim for damages based on the restitutionary measure?
Well, he wouldn't have a restitutionary claim. He doesn't have a claim in unjust enrichment, and indeed he expressly disavows that in the particulars of claim. But nor would he have a claim based on restitutionary damages. He would have to establish loss. And yet, somehow, it's said that there is a restitutionary claim against the third party. We submit that's a very surprising proposition on the face of it. One can also consider the position in this way, and here, my lady, my lords, I'm inviting the court just to look at the oddity of what the proposition is and its effects. If there had been no agreement for the license with my clients, so if my clients had simply gone ahead without a license from the executors.
So no 2016 agreement?
Indeed.
Yeah.
First of all, the claimant would have had no rights against my client in those circumstances. Secondly, if D1 had...
Because?
Well, how would it have done? My lady, in this case, the whole thrust of the unjust enrichment claims, I understand it, is it's founded on the existence of that license. Mm-hmm. But my lady, perhaps more significantly and more tellingly, if D1 had sued my clients for infringement of some rights, and let's say there was a claim that the executors could have pursued against my client, and recovered damages, there is no basis in that world in which my learned friend could have claimed a restitutionary entitlement to recover those damages from D1. From the executors. And as I said, the particulars of claim expressly disavow an unjust enrichment claim against the executors. We say that's a very odd effect.
I'm not sure I understand that last point. You may have to ask a bit more about it. But just going back to the, let's call it the OBG argument, that this goes behind OBG and opens the floodgates and so on and so forth. All of that ignores the outstanding defence, as it were, of bona fide purchaser for value, doesn't it? which you're not pursuing as a point here, but in terms of floodgates and claims and looking at the whole package of the world of unjust restitution, do we need to always bear in mind, in terms of overall outcomes, the availability of such a defence?
Well, quite possibly, my lady. The extent to which that defence arises is a matter of some... It's not entirely clear what the extent of that defence is under the law of unjust enrichment. But the point is...
I know you say we don't get there, but
but my lady, one would still be jettisoning the OBG considerations.
Yeah.
It's not to say that there wouldn't be defences for an unjust enrichment claim, but it would just completely alter the landscape.
Now, it's no doubt my fault. Just your second point was, if D1, if the executor had sued Lunak for infringement of rights and got damages from D4, there would be no basis on which Tyburn, the claimant, could have claimed damages in restitution from the executors.
No, yes, that's right, my lady. The claimant could not have said, we have a restitutionary claim to those damages in your hands against the executors. And we say that's a very... If the claimant's claim in this case has any substance, then that's a very odd outcome.
Could they have claimed a contribution?
I'm sorry a minute.
Could they have claimed a contribution
Under the Act.
But there would, in this scenario, there would have been no breach of contract on which it could found its claim,
Right.
because the executors would not have licensed the rights.
But why is any of this relevant if the whole premise is that there is a 2016 agreement?
Well, it's just a way of testing
Right.
the bizarreness of the claim that's advanced. My lady, perhaps we may come back to this. But
Yes,
we say that none of this matters, because if one looks at the principles that apply, there is no way that this claim gets off the ground. And that's where I'm going to go now, because that is based on recent Supreme Court authority in the ITC case, which is in the bundle behind tab 14. And this will require some detailed consideration. I don't know whether the court has had a chance to...
Yes, but for my part, I think we've all looked at it carefully, but I wouldn't mind looking at it again. Is that all right? Yeah.
Well, my lady, then I will trot through it. Just to set out the background, it was a case concerning VAT paid by mistake. And so far as relevant for these purposes, the factual setup can be quite quickly summarised. Investment funds had paid investment managers fees, including VAT. The investment managers had accounted to the revenue for the tax collected, less their input tax, and that was dealt with on a sort of illustrative basis as being a 75-25 split. In fact, the supplies ought to have been exempt. And so far as relevant for today's purposes, the question was whether the revenue was unjustly enriched to the extent of the 75% which the managers had paid on to the revenue. Now, at one level, it might be said to be obvious that the revenue had been so enriched. And if one picks the judgment up at paragraph 32, that is indeed what Lord Reid points out. There is no doubt that in economic terms, the commissioners were enriched at the expense of the lead claimants. On the mistaken premise that the supplies were taxable, the lead claimants were charged tax by the managers and paid it to them in accordance with their contract. On the same premise, the managers were obliged to account to the commissioners for tax and to pay the output tax in respect of each accounting period after deducting input tax. The net result of the mistake was the lead claimants were worse off by the amount of the manager's output tax, and the commissioners were better off. But, my lady, my lords, it's not that simple. The requirements of unjust enrichment require a closer analysis. And that is what then Lord Reid points out at paragraph 33. No payment was made by the lead claimants to the commissioners, nor were the managers simply a conduit or in legal terms an agent for payment. The lead claimants owed no money to the commissioners. Furthermore, the payment of the tax element of the invoices submitted by the managers was not the cause of the payment of tax by the managers to the commissioners. As explained earlier, the managers were liable to account for tax to the commissioners once they had supplied the relevant services. It couldn't be said that tax would not have been paid but for the payments by the lead claimants. So a more detailed analysis is required, and Lord Reid then goes into a general discussion starting at paragraph 37 and really it goes on to paragraph 66, all of which repays close attention. I don't know whether it's convenient to leave the court to read those passages or whether you'd prefer...
Probably, and I think these are the passages I've read very carefully. It may be that the respondent emphasises paragraph 38. I don't know whether that's just Lord Reid was not providing a definitive statement of the circumstances in which the enrichment can be said to be the expense of the claimant.
That's right, my lady, but he does then go on to say this court has a responsibility to establish more precise criteria.
Yes.
And that's what he then goes on to do.
Yes.
And it's important to understand that's what he was seeking to do. There is a need for...
And paragraph 39 emphasises that.
Indeed. So, my lady, one gets that. In paragraph 38, he was setting out to provide clear and precise criteria. And in paragraph 39, he explains that the whole approach to unjust enrichment is not a broad judicial licence. It must be determined on rules that are ascertainable and consistently applied. And that's what the Supreme Court was doing. Now, my lady, then moving on, if I pick out the bits in particular that I would draw the court's attention to from it, it's important, and this is paragraph 42, to recognise what underlies the whole basis of unjust enrichment, the whole purpose of the doctrine. It is designed to correct normatively defective transfers of value, usually by restoring the parties to their pre-transfer positions. It reflects an Aristotelian conception of justice as the restoration of the balance of equilibrium which has been disrupted. The nature, and this is paragraph 43, the nature of the various legal requirements indicated by the act at the expense of question follows from that principle of corrective justice. They are designed to ensure that there has been a transfer of value of a kind which may have been normatively defective, that is to say, defective which is recognised by the law of unjust enrichment, for example, because of a failure of basis on which the benefit was conferred. The expression transfer of value is, however, also too general to serve as a legal test. More precisely, it means in the first place that the defendant has received a benefit from the claimant.
It doesn't have to be money, necessarily.
It doesn't have to be money, it could be services, classically. That is not in itself enough. The reversal of unjust enrichment, usually by a restitutionary remedy, is premised on the claimant also having suffered a loss. That last point then, though, is picked up at paragraph 45. Doesn't need to be a loss in the sense of law, as in the law of damages. Restitution is not compensatory. So for that reason, some commentators prefer to use different terms, referring, for example, to subtraction from or diminution of the claimant's wealth, or simply to a transfer of value. But loss, the word loss used in the authorities, and it's perfectly apposite, provided it's understood that it does not bear the same meaning as the law of damages. The loss of the claimant may, for example, be incurred through the gratuitous provision of services which could otherwise have been provided for a reward. In such a situation, the claimant has given up something of economic value through the provision of benefit. So there must be a transfer of value. Then, in paragraph 46, Lord Reid points out that normally it will be a provision of or a transfer of value because the parties have dealt directly with one another, and so the payment of the receipt of the benefit will have been direct, including gratuitous payment of money, provision of services, etc. There are, however, this is paragraph 47, situations in which the parties have not dealt with one another directly or with one another's property, in which the defendant has nevertheless received a benefit from the claimant and the claimant's incurred a loss through the provision of the benefit. And Lord Reid then goes on to outline what those situations are. He gives some examples, and just running through them. Paragraph 48, the first situation is a situation of agency. So, although there will be a third party interposed, that third party's role is that of agent, and one can well see why that is really akin to, or legally equivalent to, a direct transaction. The second example is assignment. That's at the top of the page in paragraph 48 on page 384 of the bundle. Assignment, again, that is legally equivalent to a direct transfer. The third situation is sham, and one sees that at letter B. And that's where the court will look through steps that might be taken to dress it up as an indirect transfer and treat it as a direct one. Then the fourth example, just above letter C, there have been also cases discussed below in which a set of coordinated transactions has been treated as forming a single scheme or transaction for the purpose of the at-the-expense inquiry on the basis that to consider each individual transaction separately would be unrealistic. Now, I'll come back to that because this is apparently relevant to the way the claimants put their case. But we will say in due course that there's no way in which this situation...
Well, that is the basis on which the respondent puts the case.
Indeed, that's the way it's pleaded, apparently, yes. And we'll come to that where Lord Reid discusses it in some more detail. But then just to carry on with the analysis, at paragraph 49, Lord Reid identifies a slightly different situation where the claimant discharges a debt owed by the defendant to a third party. So there it's a third party creditor who receives the payment, but the defendant is enriched by the discharge of the debt. In that case, the remedy that's generally given is one of subrogation to the party's rights against the defendant. Then picking it up at paragraph 50.
So no rule of no requirement of direct benefit.
Well, there is a direct benefit in effect because the claimant, because in that situation, the claimant discharges the debt and the defendant benefits through that discharge. It is done through the payment to the third party. One could quite see how one could characterize that as in effect a direct benefit, albeit it's not...
I was wrong. It's saying the opposite. It's saying that there is a general rule.
I don't see Lord Reid as saying that is an exception. It is just a different type of situation. He then goes on at paragraph 50. It's often been suggested there is a general rule, possibly subject to exceptions, that the claimant must have directly provided a benefit to the defendant. The situations discussed in the two preceding paragraphs can be reconciled with such a rule. So, my lady, that's the point. If it's understood as encompassing a number of situations which, for the purpose of the rule, the law treats as equivalent to a direct transfer, in the sense that there is no substantive or real difference. So understood, the suggested rule is helpful. It may, however, it may nevertheless require refinement to accommodate other apparent exceptions, and it will be unwise at this stage of the law's development to exclude the possibility of genuine exceptions or to rule out other possible approaches. Where, on the other hand, the defendant has not received a benefit directly from the claimant, no question of agency arises and the benefit does not consist of property in which the claimant has or can trace an interest. It's generally difficult to maintain that the defendant has been enriched at the claimant's expense. And there's a reference then to a case of MacDonald and Dickens. And then it's also illustrated by the example given in the Reltho case of the claimant who makes a mistaken payment to a third party who in consequence makes a difference to the defendant out of property in which the claimant has no interest. Now, my lady, Lord Reid then goes on to the section headed incidental benefits, which I don't think we need to be directly concerned with here, because I don't think this is a case on any view of incidental benefits. I will come back to that passage in due course on a smaller point later. But then picking it up at paragraph 59, Lord Reid, under the heading Economic Reality, explains why it is not legitimate to look at the matter simply as a matter of economic or commercial reality. Nor is the at the expense of requirement satisfied by a connection between the parties' respective benefit and loss, merely as a matter of economic or commercial reality. And he explains why. And in paragraph 60, a more fundamental difficulty with an approach based on economic reality arises from the fact that the purpose of restitution is not to compensate for loss, but to reverse the defective transfer. Looking to see who suffered an economic loss is not, therefore, in principle, the correct way of identifying the appropriate claimant. Indeed, even in tort law, which is concerned with compensation for loss, the court is not concerned with where the economic burden of the tort may ultimately fall as a matter of economic reality. That is important because in our submission, what one can discern from the claimant's case throughout this is there is a sort of broad plea to, well, we've suffered loss, supposedly, by this breach of contract. And the Fourth and Fifth Defendants have benefited from it, and therefore, as a matter of justice and economic reality, there should be some sort of recompense. But, my lady, that's not the way the question should be approached. There is then a section dealing with coordinated transactions. This is dealt with in particular by reference to the Banque Financière case and the Meneleu case, which I won't go into. They're in the bundle, but Lord Reid discusses the facts of both of them, and what one can clearly see is that the facts were such that although the conferring of the benefit was indirect, it arose by reason of transactions that were a preordained set of steps which entitled the court, in effect, to collapse them into one.
Preordained or set on steps, did you say?
Preordained set of steps.
Set off steps.
Which enabled the court to, as it were, collapse them into one. So, in dealing with Banque Financière, picking it up at paragraph 62, just at the bottom, this was a case where a loan was made. They wanted to make a loan to a company. Because of Swiss banking rules, it couldn't be made directly to the company, so the money was advanced to an individual who then loaned it on immediately to the company.
Yes.
Lord Reid points out that on both analyses, the House of Lords treated the situation as one where the defendant had directly received a benefit from the claimant, since on one analysis it was in reality the claimant which had discharged the first-ranking security and thereby promoted the defendant's security, and on the other analysis it was the claimant's money which had done so. But the important point was that they were a preordained set of steps and pretty much simultaneous, resulting in the money going from the claimant to the company via the director. And then picking it in paragraph 63, Lord Reid deals with Meneleu's case, which is where money was used to buy a property and discharge security. Again, it was a transaction which was entered into more or less simultaneously through the money passing, and it's summarised in paragraph 65, where Lord Reid points out that Lord Clerk proceeded on the basis that the two arrangements, namely the sale of the property, first property, and the purchase of the second property, were not separate but part of one scheme which involved the bank throughout. Lord Newburger observed that it is appropriate not merely to consider the purchase of and charge over the second property as a single transaction, but it was also appropriate in the present case to treat the sale of the first property and the purchase of the second property as one scheme, and Lord Clark described it, this is paragraph 66, as in reality a single transaction. So that's addressing the sort of claim one might see where one is having coordinated, a coordinated series of transactions where they can, in reality, be treated as one. And that enables indirect transfers to fall within the scope of an unjust enrichment claim. Now, that's Lord Reid dealing with the principles. He then comes back at 67 and following to pick up the particulars facts of that case, and remembering that he had observed in paragraph 33 that on the face of it, the revenue had been enriched, but he concluded that it was not at the expense of the investment funds because it was not a direct payment and did not fall within the coordinated transactions exception, in particular paragraph 72, picking it up under thirdly, the fact that there were two separate transactions, first between the claimants and the managers, and secondly between the managers and the commissioners, is not in this context something which can be disregarded. In particular, there's no question of the transactions being a sham or involving an artificial step or of their comprising a single scheme. The first transfer did not even bring about the second transfer as a matter of causation. The judge's rejection of a but-for causal connection between the two transfers is not alleged. Sorry, not challenged. So those are the principles, and they are principles which the Supreme Court intended to set by way of clear and precise rules to define the scope of an unjust enrichment claim.
It might be said, Mr. Cullen, mightn't it, that the only type of restitutionary claim that was under consideration in ITC was a defective transaction which was intended in the first place by the claimant. It's normally defective because of a mistake, but in that circumstance, the claimant did intend these transactions to occur. A completely different type of case is one where the defendant has usurped a benefit which would otherwise have been available for the claimant, like the usurpation of office cases referred to in Boff and Jones.
I'm going to come to that a bit later. But, my Lord, on the face of it, no. He's dealing with unjust enrichment claims in toto, and he expressly mentions, for example, the Relfo case, which was a case of, as it were, lack of consent. That was where a director had stolen money from the claimant, in effect. So he's dealing equally with all cases of unjust enrichment, regardless of what is, as it were, the unjust factor, which is what your Lordship's point is directed to. There will, in various cases, there'll be a different unjust factor. Often it will go to the consent or the authority to do an act.
But the need to look for coordinated transactions just doesn't arise, does it, if the restitutionary claim is one based on usurpation of a benefit without consent, without authority?
You may have that, and one has that in the Relfo case, where, I don't think that's in the bundle, unfortunately, but that was money being taken from a company and being channeled through to, as it were, the wrongful recipient. It wasn't done directly, but the court treated it as, in effect, one transaction because it was it was all, as it were, preordained. Now,
it was taken by the director, was it?
Yes, it was.
The company through its director.
In that case, what this might go to, my lord, is who has to do who's coordinating, as it were. Now, in a case where the claimant is acting, as it were, by mistake, but voluntarily. So where it is the claimant's act of will, then one might very well say that the coordination needs to be the intention of the claimant. But where the claimant does not consent, and where the wrongdoing is done by, for example, a director, then in that case one might be looking at whether the wrongdoer was acting through as it were, in a coordinated fashion. But, my lord, it's nonetheless got to be a coordinated transaction sufficient to enable it to be treated as, in effect, a direct transfer.
Just taking that one stage further, as I understand the case that's put against you, you're not the wrongdoer, and neither is the claimant. The wrongdoer is the party in the middle in this case, let's say the third defendant, or possibly the first, second, and third defendants. And if you look at what's happened in this case from the perspective of if that's the injustice, that the person that gave your client permission is alleged to have done so knowing that, in fact, they should also have got the permission from the claimant. What's uncoordinated about that? Isn't that as coordinated as it might need to be when you look at it that way? Not looking at it from I understand if you look at it from the claimant's, start at the claimant, I can see why it doesn't look very coordinated, but if you look at it from the perspective of the party in the middle of this, why is that not coordinated?
Well, my lord, it has to be coordinated with something. The claimant must have, for there to be a transfer of value, there
I
has to
understand.
be...
I know you say there isn't a transfer of value. I get that. That's a different question. What we're talking about at the moment is this coordination aspect. And what I'm putting to you is essentially the same point that my lord puts.
Well, it does come later down the line, but certainly the way it's pleaded is the coordination is the series of transactions involving the claimant, the executors, and and my clients.
Yes.
And for there to be a coordinated series of transactions at all, then there has to be a transaction to which the claimant was a party, and the only such transaction one has is the 1993 agreements. Mm-hmm. So if the assertion is that there was a coordinated series of transactions whereby property got from the claimant, or whereby a benefit got from the claimant to the defendants, then the only candidates are the 1993 agreement and the 2015 agreement. Mm-hmm. Now, I'm getting ahead of myself in the argument, in a sense, but one only has to give the dates of those agreements to make it absurd to suggest that they were coordinated, could possibly have been coordinated.
I think I've got two questions. The first is, when you look at coordination, does it have to be prospective or can it be retrospective? So my Lord's question is premised on it being, you can trace it back. And my question to you is that the right way of looking at coordination? Does the coordination, as it were, have to be prospective, i.e. part of a, I don't know, what's your position? Can it be retrospective in the sense that my Lord identified it, or has it got to be something, as it were,
It has
there at the beginning?
It has to be prospective in the sense that it has to be, the clue is in the word, coordinated. It has to be pre-planned. There has to be something at the outset whereby the parties start at point A knowing they're going to get to point C
Yes, I see
via point D.
Yes. Second
B,
question.
sorry.
Sorry, go on. Yeah.
Now,
The second question I have is just, and I suspect I'm taking you well out of the order of your arguments, but if I can just park it now. There are 2 points, as my Lord points out. The first is there a transfer of value? And you're going to come to that.
Yes.
Then there's this coordination point. Are they separate? Or can you win on either? Obviously both, but could you win on just coordination, for example? Or if there is a transfer of value, is that essentially the end of the argument?
if there's no transfer of value, that's the end of it.
Yeah. But if there is a transfer of value, is that an end of it?
If there is a transfer of value, then my learned friend has to show that it's either that it's received directly or to be treated as directly through one of the exceptions.
So you say there is a separate coordination hurdle?
Yes, there is a separate coordination hurdle.
I'm not saying it's right or wrong, I'm just asking
No,
what your case
that's
is.
certainly our position, my lady, and we say that follows from what Lord Reed said.
So first of all, you say you can succeed if you establish no real prospect of establishing transfer of value. But even if you're wrong about that, you say you can knock the claim out because even if there was a transfer of value, there was no direct transfer of value in the extended sense identified by Law Reed and ITC.
That's right, my lady, yes. Now, one of the difficulties in analysing, Brendan, this might be my Lord's difficulty in analysing the coordinated transaction point, is that, and this is the sort of liminal question, here there's simply no transfer of value at all, and so it's very difficult to get a grip on whether or not it's coordinated. And it's a very short point, but we say obvious. What the claimants had was the benefit of a covenant, a restrictive covenant against doing certain things. It still has the benefit of that covenant and possibly a claim for damages against the executors. It simply hasn't, nothing has been transferred from the claimant to my clients. Now, there's not really much to say on the point. It's just, we say, blindingly obvious that nothing has been transferred from the claimant to my client.
Well, the respondent says it's something akin to property rights.
Well,
And what do you say to that?
well, first of all, it's not akin to property rights. It's simply a contractual right. And whatever it is, it wasn't transferred to my clients. What happened on my learned friend's case is the first and second defendants breached their contract. But there simply was not a transfer of value.
So isn't what you got a consent? You got a consent,
We got a consent.
and the consent you should have got was from them, and the one you got enough of a consent from the estate to mean their consent, which is what you should have had,
Yes.
got to you.
We were under, well, to be clear, we were under no obligation to get a consent from the claimant.
But what you have got, as it said, as I understand it, is a consent, and the consent that they say you've got is what you should have got from them. Not because you necessarily did anything wrong, but that's what you've acquired.
I don't think they say we should have got the consent from the claimant, and I don't see how they could say that. They say that the executors should have got a consent from them before granting us a consent.
Okay, you're right, and I'm not putting it properly. What they say is the effective consent which you needed was one which needed to come from both parties, them and the estate. You've got an effective, that's what they start with, and they say, and you've got an effective consent.
We got a defective.
No, effective.
Effective
That's the
consent,
point.
yes,
That's the point.
yes.
If you had a defective consent, we wouldn't be here.
And we got an effective consent from the party from whom we were required, assuming that what we did would have infringed the executor's right. We got an effective consent from the party from whom we should have got the consent.
Well,
That was not a transfer.
maybe, but what they say is if the party who gave you consent, in fact, didn't have the power to give you the consent they gave you. Now, they did give you have got an effective consent,
So to that extent,
You're free.
to that extent, they did have the power to give the consent because it was within their gift to give it.
No, they didn't give the claimant's consent.
No.
They gave their consent. So insofar as the claimant had anything to transfer, its consent, that wasn't given.
No.
So the consent that they got under, your clients got under the 2016 agreement was the consent of the executors.
Which is the only consent.
The only consent that the executors could give. The executors didn't and couldn't give the consent of the claimant, the respondent. So the claimant's consent, if that was the right value, was not transferred under the 2016 agreement.
No.
And was not something your clients received.
No, and nor were we required to obtain it.
Yeah.
Clearly, if we'd had notice of the 1993 agreement, then when one gets into OBG and Allen type territory, that we might have been committing some tort in not ensuring that the claimant obtained the consent.
But Mr. Cullen, if you stand the day before the 2016 agreement and don't ask what your clients knew or didn't know, and I understand the point you made about OBG and Allen, but ask the question, in order to lawfully exploit the rights in question, whose consent is required? If you ask that question, the answer the claimants give is it was both the claimant and the estate.
But also
That is what the consent, someone who wanted to exploit these rights needed in order to exploit those rights, the consent of both. Now, true it is that the nature of the two people concerned, the claimant in this case and the executors, means that the executors in fact, and it is said in breach of contract, but I understand that is not your problem in a sense, I get that, the estate can give a consent, but if you ask the question before they've done it, whose consent is required, the answer was both Tyburn and the estate.
My lord, no, with respect.
Well, that's the issue, though, isn't it?
Well, the way, by expressing it in that way, your lordship might be taking some sort of broad, the economic benefit type approach,
Not at all.
which Lord Reed said isn't the correct approach. So far as my clients were concerned, all they needed was the consent of the estate, and that is what they obtained. What's the claimant did not have any sort of property right which we required to clear through them.
There's nothing invalid about the consent under the 2016 agreement.
No. We got all the rights we needed. No one can sue us for infringement of any intellectual property right.
Well, I understand that, Mr. Cullen, but that's one of the curious things about consents. Because if the rights holder, I mean, you know what this is the whole thing about exclusive licenses. The rights holder, in a case of an exclusive license of a right, like an intellectual, the owner of that right can in fact give a consent to a third party,
Yes.
which is a breach of the exclusive license. On general legal principles, that consent is effective to mean that this is not an infringement by the third party. That's the general position. They breach their contract, they breach their exclusive license contract in doing that, but in principle they can do it.
The owner can.
The owner can.
Yes.
The owner always can. So
Yes.
from the perspective of a third party, in that sense, your clients are the third party in that case, they can say what you've just said, which is all we need is the consent of the rights holder.
Yes.
And you're right in that sense. On the other hand, if you approach it by asking before the third party has acquired that consent, which would have been given in breach of contract, whose consent is required in a case where there's an exclusive license, the natural and simple answer is the consent of the exclusive licensee. Now, it's true that the third party can in fact acquire a consent from the rights holder, that's true, but it's not quite as simple as that. That's the point that I'm putting to you.
My lord, it perhaps isn't, as a matter of commercial reality, you may need consent of both standing before. But, my lord, it's interesting to look at this case. What if the claimant actually had an exclusive license rather than this purely restrictive covenant? And what if we had gone ahead simply with the license of the owner of the rights? Now, there are a number of, if you leave aside the statutory provisions, leave aside the existence of the Copyright Act.
Yes, absolutely.
If one just views it in isolation, then what would be the position? And the position we say is that in those circumstances, the claimant would only have its claim for damages against the licensor.
Yes.
It would have no claim
I
in
agree with you. I
restitution
agree. I
or
put that to you.
damages or any other sort of claim against my clients in those circumstances. So pausing there, it's rather odd that someone with this nebulous, akin to property, however my own friend puts it, right, should be in a stronger position than an exclusive licensee.
But that does beg the question, and I mean, just to be clear, I think what's been put against you is what you've just said isn't right, isn't correct, because they would have, the whole point of this case to some extent is that they would have a right of unjust enrichment in those circumstances,
Well,
if they're right about what they say. But where we got, I will stop, but where we got, what woke me up, if I can put it that way, that's not an appropriate way of putting it, but the reason I started asking you questions, Mr. Cullen, is about the question of what did you get? And what I'm putting to you is that you did get something, and it's a consent. Now, I understand you say it hasn't been transferred. I do get that, but I think that's, at least as I see it anyway, that's the thing that you got.
but we didn't
You
get...
said, I know you say you didn't get anything, I understand that.
What we got, my lord, was the consent of the executors. We did not get the consent of the claimant. That's why these proceedings have been begun, because the claimant didn't give its consent. So it can't possibly be said that there's been a transfer, and this isn't the way it's pleaded or put, but if the suggestion is that the transfer of value exists in the giving of the consent on behalf of Tyburn, well, that's simply not sustainable. We didn't get that consent. That's not what the executors did.
Yeah.
The executors simply gave the consent they were able to give. That is all my clients required. So on that scenario, we say there cannot possibly be a claim that there's been any transfer of value. And just to come back to the exclusive license example, because we say it is the case that if a copyright owner, if the claimant here were an exclusive licensee, if the owner of the rights granted a license in breach of that to us, then the exclusive licensee would not have still transferred anything of value. It would still have its exclusive license. Its claim would lie exclusively against the grantor, with potentially an OBG type, an Allen type claim against my clients if the ingredients could be made out. Of course, that's looking at it without statutory intervention. Of course, under the Copyright Act, my Lord Justice Burst will know, and no doubt the other members of the court also, as an exclusive licensee, Tyburn, if it had an exclusive license, might or might not be able to bring direct claims for infringement. But in that scenario, in any event, one is thereby going into a world of a statutory scheme, which on my learned friend's case would anyway exclude claims for unjust enrichment, and that's part of his argument that he makes in relation to the floodgates.
Just on the exclusive license, you said, leaving aside statute, you say there's no transfer of anything. It might be said, mightn't it, if there is an exclusive license, that carries with it the right to exploit all and every benefit from the use of that license. So if there is a wrongful grant of rights by the owner, the holder of the rights, to the defendant, then it could be said that there has been something of value transferred because that person has now received value from exploitation of those rights, whereas it should have been the claimant that had all of that value.
Well, that's certainly not what one sees in any of the cases. In the cases, the it's slightly complicated by the fact that
It's overlain by statute now.
it falls within a statutory scheme, so different considerations apply. But certainly I'm not aware of any case where it's been said that an unjust enrichment claim would lie in those circumstances. The way in which one would orthodox bring the claim would be by way of damages against the licensor, and if you've got a claim for inducing breach of contract against the licensee. Against the second licensee, as it were. But at any rate, my lord, with respect, I'd say no, there still is not a transfer of value. There is simply a grant that is in breach of contract. There is nothing that's been taken from the claimant. The claimant still has its rights. Part of those rights, then, the value of those rights might then consist in a claim for damages against the licensor. But it's simply unrealistic, in my respectful submission, to suggest that in those circumstances there's anything that can sensibly be called a transfer of value.
Right.
In a sense, the whole point of a claimant in those circumstances is saying this was not something I consented to, and not something you can take from me, and hence I bring a claim for breach of contract. So, my lady, my lords, we say the short point in this case is that there is no conceivable transfer of value from the claimant to my clients. And then if one begins to try and analyse it in terms of direct or indirect transfers, plainly there's no direct transfer. The claimants were not involved in any transaction with my clients. They weren't a party to the recent agreement. They didn't, in fact, provide any benefit. They didn't part with anything as part of any transaction with my clients. The most they can say is that the agreement with my client should not have been entered into without its consent. And they do say that. That does not constitute a transfer of value. And if one then tries to analyse it in terms of indirect transfers, we say the claim is hopeless. It relies on the assertion of coordinated transactions involving the various parties. Those coordinated transactions can only be the 1993 agreement and then the 2016 agreement, and the suggestion, any suggestion that those are coordinated is frankly for the birds. The fact is the 2016 agreement, far from being coordinated with the 1993 agreement, was entered into in breach of it, quite apart from the fact that they are so separated in time as to make any such assertion hopeless. Now, my learned friend Skeleton talks repeatedly about their rights being akin to property rights, and that by entering into the license, the estate was wrongly exercising the respondent's veto and/or blocking right. That's the way it's put, and this comes back, I think, to my lady's point. That's not what was going on here at all. The estate was not exercising the claimant's right, it was breaching it. And to suggest that this was, as it were, the claimant giving consent on behalf of, the executors giving consent on behalf of the claimant simply is not the reality. It's rewriting history and creating a fiction.
I hadn't picked that up. Is that said to be the case?
That's what's said in, it's not the way it's pleaded, it must be said, but if one looks at the respondent's skeleton argument at, for example, paragraph 43, by permitting the appellant to resurrect Mr. Cushing, the estate was wrongly exercising the respondent's right to veto or block the same.
No, well, that's not saying on behalf of.
Well, I'm sorry.
Well, I see what- Okay.
That's perhaps I mischaracterised the way it's put. But at any rate, they seem to be saying, whether it's on behalf of or by what some other means, I don't know, that what's going on here is the estate was exercising the claimant's right of veto. That's not what was happening at all. Now, so we say that when one, even if one can get over the transfer of value point, when one tries to see whether there is a direct or indirect transfer sufficient to satisfy Lord Reed's analysis, it is impossible to identify anything of the kind. All one has is a breach of contract, on the claimant's case, by the estate. But there is no transfer, direct or indirect, of anything going from the claimant to my clients. Now, it's convenient to address some textbook commentary which my learned friends rely on, and this comes back to...
And are you going to go to SCAT at any stage?
well, my lord, my lady, we can look at that briefly now.
Well, are you relying on it?
We do rely on that because that is a good example of, just to turn it up, of the way the court has subsequently interpreted the coordinated set of transactions test. One sees it behind tab 20 in the bundle. And I don't say that it says anything new.
No, it's in its first instance, it's illustrative, you say.
But it does provide a helpful indicator of, if you like, the narrowness of the coordinated transactions test. It's a somewhat, it's an immensely long judgment, and only part of it relevant to the unjust enrichment claim has been included in the bundle, but one sees it at paragraph 40 behind page 638. And basically, the Swedish tax authorities had paid out to various, in response to various dishonest claims, to various entities. And it was held, in short, that only those to whom payments were directly made or to whom, where an agency relationship existed, only those were recoverable in unjust enrichment, and any other claim, any other recipients could not be said to have been enriched at the expense of SCAT because there wasn't the necessary coordination. As I say, I don't think that adds anything, but it is a useful indicator of the narrowness of the exception.
So you wanted to go to the to Goff and Jones?
Yes. So to look at Goff and Jones, and this picks up, I think, Lord Justice Zacaroli's point about he mentioned usurpation of office type cases, and I think my learned friends rely on this under the rather ghastly jargon of interceptive substitutions.
I can tell you it means nothing to me.
Sorry?
What I can tell you, it would mean a lot to my lords, but it means nothing to me. Interception of...
Interceptive subtractions. I'm sorry, even I got it wrong. Interceptive subtractions.
Right.
It pick it up behind tab 22 in the bundle.
Yes.
And for some reason it appears broken up by tab 23, but the whole section is in the bundle at tabs 22 and 23. And the court will no doubt look at those in due course. What this type of case involves is, as Lord Justice Zacaroli described, as usurpation of office, where someone for example, takes it upon himself to act as an executor and collects in debts of the deceased. And in those circumstances, the actual executor may have a claim in unjust enrichment against the person who has usurped the office. Of course, that scenario assumes that the person who has paid the usurper has got a valid discharge, because otherwise the actual executor could just go and collect from the third party in the ordinary course. Now, without looking at all the text, as I say, the court will no doubt want to look at it in due course. What one sees from the text is that the authors question whether this is really unjust enrichment at all. These situations will often be addressed by other principles, such as executive de son tort, which deals with a specific situation of the someone who usurps the office of executor. Various examples of the sorts of situations that might arise are set out at paragraph 6131. So there's a case where X labouring under a mistake has conveyed property to D, which X has contracted to convey to C, and where D has been held to be a trustee of the property conveyed. And then there's where X, who intended to give a gift to C, has by mistake executed a formal gift inter vivos in favour of D, or cases of attornment where X receives the funds from X to hold to the use of C, and D agrees to hold the fund, then once D attorns to C by communicating to C that he holds the fund for C, C could bring a claim for money hadn't received. Now, what these cases, their hallmark, as it were, is of property which is intended to go to A and has gone to B either by mistake or for whatever reason, because there has been, to use the word, usurpation of office or something of that kind, or to use the rather more unattractive interceptive subtraction, such that the rightful recipient can say, no, I should have that money, and it can put the claim as a matter of unjust enrichment, arguably, although, as I say, the authors of Gothard and Jones aren't entirely clear as to whether that's really an unjust enrichment case. We say that can't have any possible relevance to the present case, because what we've received is a license to use Mr. Cushing's likeness in our film. There's no way on earth that it can be said that that's a license which should have been granted to the claimants. If the claimants wanted a license to use Mr. Cushing's likeness in some other film of theirs, no doubt they could have gone to the estate and negotiated for that. But to suggest that the license we received was somehow intercepted from the claimant and should have gone to the claimant is just not the reality. Again, one comes back to it. All that's happened on my learned friend's case is that the executors have acted in breach of the contract. They have not given us anything that the claimant had some contractual entitlement to. The claimant wasn't contractually entitled to the license we were granted. So we say that this area of interceptive subtractions simply has no application to the facts of our case, even assuming that it is validly to be regarded as an area or a species of unjust enrichment claim. Whilst we're in the bundle, it's perhaps worth also turning up tab 24, which my learned friend also relies on, and I think the judge referred to, and in particular paragraph 801, and there's about 6 lines in, they also include a different category of cases exemplified by misapplications of trust assets by trustees and misapplications of corporate assets by directors, where X owns or controls assets subject to duties and powers to deal with the assets for the benefit of another, where D is enriched as a result of X's unauthorized dealings with the assets. Now, this is a section dealing with the unjust factor of lack of consent, and all that is doing is describing certain situations where that arises, classical ones of breach of trust by trustees or breach of trust by directors. None of that has anything to do with this case. The estate didn't hold assets subject to any fiduciary duty to the claimant. It wasn't required to hold anything for the benefit of the claimant. So it hasn't dealt with the assets in any way in breach of any obligation of the kind discussed in paragraph 801. We're simply not in that territory. We are dealing here not with any property rights, however much my learned friend says they're akin to property rights or whatever. These are simply contractual undertakings given, and one simply isn't in the territory referred to those kinds of cases covered by paragraph 801 of Goff and Jones. So, my Lord, I was going to then move back to what might be described as the floodgates argument, which we've touched on already. Of course, it's not, or at least not only a floodgates argument, it's about testing the principle. Because if the principle is as the claimant suggests, then the breadth of the remedy, we say, would be broadened to a quite extraordinary extent. We've given in our skeleton argument some examples of reported cases where a restitutionary claim would have lain on the claimant's case, but where numerous learned and distinguished counsel had apparently not noticed this. The claimants say...
Paragraph is that?
That is... at paragraph 53 and onwards.
Thank you very much.
Now, the claimants seek to sideline some of those. For example, Isaac Oren, they say, concerned a case of where there's a statutory scheme.
Sorry, forgive me, it's not my page. Did you say para 53?
Sorry, paragraph 53. I'm sorry, my lady. It's page 34 of the bundle.
I'm not sure it is the right paragraph. I'm looking for the floodgates. I see, para 54.
And over to 57. That's all in the same sort of area, my
Okay.
lady, as
Yep,
to
thank you.
what the consequences would be. My learned friends seek to distinguish, for example, Isaac Oren. They say, well, that's a case where there was a statutory scheme concerning registered designs, and that therefore would oust any unjust enrichment claim. Now, as to that, well, they rely on the case of Loan against Hanslow, which decided that the statutory scheme in relation to recovery of rates, I think it was, ousted any claim for unjust enrichment on the basis that the statutory scheme was inconsistent. There's scope for argument, no doubt, about whether the unjust enrichment claim would truly be ousted in a case And if it's not in a case of for example, infringement of intellectual property rights, and indeed, if it is ousted, one might ask, why is it not ousted in this case, since the claimants are, in substance, effectively asserting something akin to performers' rights. And it's odd that a claimant who doesn't have performers' rights should be in a better position than someone who actually does have performance rights. But in any event, my lady, my lords, these are just illustrations. One can think of plenty of others existing outside of any possible statutory scheme, where, if my learned friends are right, a claim would arise in unjust enrichment. If one considers, for example, a standard employee subject to post-term restrictive covenants. Or my learned's case, if that employee goes to work for a competitor and breaches covenants by soliciting existing customers without the consent of the employer, then on the claimant's case, the employer would have a claim for unjust enrichment. Because the situation would be entirely the same as the present one, whereby the new employer was benefiting from a breach of covenant by the employee and thereby harming the original employer.
Might it be said that the trouble with that is that the employer might have a bona fide purchaser type defence?
Well, that may be a consideration, and one would get into all sorts of arguments about that. I'm not saying that the claim would win, but it would have a potential claim.
Right.
Now, that would be news to everyone. One doesn't see any such claim made on the authorities. It would be inconsistent with one step, which I showed the court earlier, which was a case involving breach of restrictive covenants by employees, where there's no suggestion that there would be an unjust enrichment claim. The consequences of this argument being correct are very, very broad indeed. They would cover any situation where there is a breach of contract by a party causing loss to the claimant and from which the defendant benefits, obviously subject to defences, but they would be different defences than one would see in orthodox cases of such claims. Similarly, another example would be breach of confidence, where there's a breach of a contractual term to keep information confidential. Of course, there one is getting into, although it's somewhat murky territory, whether that's to be regarded as property right or not, but it's more savouring of that sort of argument. Again, in such cases, to my knowledge anyway, there is no instance on the authorities where such a claim has ever been advanced on an unjust enrichment basis. One does have in the authorities bundle racing partnership against Dunn Brothers, which my Lord Justice Zacaroli will be familiar, where it was argued long and hard all sorts of economic tort claims and the like. I don't understand there ever to have been any suggestion that in fact the claim could have been advanced on an unjust enrichment basis, on the basis that there the defendant had received confidential information in breach of the claimant's contract with a third party. It's on all fours with this case, in all relevant respects. So if this argument is right, it has very, very broad ramifications. And we say it's simply extraordinary that that could be the case, that this is the first time it's ever been raised. Now, so that's what we say about the correct position as a matter of law. Then to come back to the judge's approach, and I can deal with this fairly briefly, He essentially determined that it was a sensitive inquiry in a developing area of the law. But we simply say that that was a wrong approach, that the correct legal position is as I've described it. It is clear on high and recent authority. The relevant facts were common ground, or to the extent they weren't, they could be assumed against my client anyway. One can't discern from the judgment anything in the facts that might have impacted on the argument, and I don't understand from my learned friends that there's anything in the facts which would alter the analysis. There is no factual issue that needs to be determined in order for this court and in order for the judge below to have dealt with the point. It may be that one can't deal with an area of controversy in a developing area of the law where the facts may have an outcome, may have an effect on the outcome. But to the extent this is a developing area of the law, that does not give one carte blanche to make any old claim, to attach the label unjust enrichment to any old set of facts, and to be entitled to go to trial. The judge was required to conduct a deeper analysis whether, in fact, this claim had any real prospect. And for the reasons I've given, we submit that it's clear that this claim does not have any real prospect. This case is so far removed from anything recognisable as being at the expense of that the court can safely give judgment. Now, my learned friends, in their skeleton argument, rely on some authorities in this context. In particular, first of all, picking up from their skeleton at paragraph 37, they refer to TfL management and on page 114 of the bundle, and they refer to Lord Justice Beatson. They underline in bold the bit where he says, "I do not consider it's appropriate to give summary judgment on the basis of a general principle barring restitution in respect of benefits conferred." My lady, my lords, the difficulty with that is that Lord Reed in ITC went out of his way to say that Lord Justice Beatson and his fellow judge in the majority in that case had got that wrong, and they should have given summary judgment. And one can see that if your lordships turn up, ladyship turn up in ITC again. This is the passage I said I would come back to under the heading incidental benefits, behind tab 14 of the authorities bundle. At paragraph 56, where Lord Reed refers to the importance of identifying a loss arising through the provision of a benefit as illustrated by the TfL case, where they sought to recover costs incurred in earlier legal proceedings, which had, it was said, benefited the bank, which was then able to assert a claim as a result of that.
Anyway, it's the last sentence of paragraph 57.
Indeed. The whole of 57 is relevant, but in particular it's the last sentence where they say that the Court of Appeal should, even though it was dealing with a strikeout application, should have summarily dismissed the claim. While we're in the authorities bundle, my lady, also, my learned friends refer in this context also to, this is in paragraph 70 of their skeleton argument, to two cases where it said that the court wasn't prepared to deal with unjust enrichment claims on a summary basis. Just to look at those cases, first of all, there is matrix receivables, which appears behind tab 19. Where Mr. Justice Friedman was not prepared to give summary judgment, reverse summary judgment in respect of an unjust enrichment claim. But if one looks at the judgment, one can see at paragraph 54 and following at page 606 that actually the issue in that case was all about limitation period in relation to restitutionary claims. So it's not about the principles of restitution at all. And then the other case that is relied upon is the Turner trading case, which one sees behind tab 18. This was an unjust enrichment claim which was dealing with the situation where the benefit or the transfer didn't happen directly because it happened through the mechanism of bank operations, ordinary bank operations, and the recipient, if you like, applied to strike the claim out on the basis that it was not made directly and therefore not at the expense of the claimant. And Judge Paul Matthews, although he departed from an earlier decision called Technomont in this respect, didn't just refuse to grant summary judgment, but actually went out of his way to decide the point in favour of the claimant. And one sees that at paragraph 94. In my judgment, whether one looks at this case as one of agency or simply, this is different, in this case, a series of coordinated transactions, either way it involves an enrichment of the applicant at the expense of the respondent by indirect transfer. So it wasn't the case that the court there didn't or refused to deal with the issue on a summary basis. It just decided it contrary to, directly contrary to the position adopted by the applicant for reverse summary judgment in that case. So what that case shows and what the Supreme Court in ITC shows is that this is an issue that can be dealt with on a summary basis. And we say this is an issue that on the facts of this case can be dealt with on a summary basis, because we say there is no arguable way in which it could be said that the Fourth and Fifth Defendants in this case have been enriched at the expense of the claimant.
Any questions, Carl? Any questions at this stage? No, thank you.
My lady, my lord, I've come in well ahead of time.
No, you've done very well. Thank you very much indeed, and thank you for answering our questions so patiently and clearly. What was the anticipated timetable for your submissions?
It rather depended on how things went and
Yes, well, having heard and felt how they went, where are we? Were you aiming for 12:15 is my question.
I'm sorry, my lady.
Were you aiming for 12:15?
I was aiming for somewhat later. I thought it might take me a bit longer, but I'm
Good. Well, I think we'll have a 5-minute break, if that's all right. Well, let's say 10. Yes. 5 always turns into 10. Will that give you enough time?
My lady, certainly. I think Milona Friend's 20 minutes ahead of where he was
well,
aiming
we'll have
to be, and I
we'll
don't
come
seek
back
to take them.
at 12:20 and look forward to hearing your submissions. Thank you very much indeed. Can I just say it's very cold? Are you cold?
not. But
I've got suet around my kidneys.
All right. Okay. Good.
No, you're all right. Someone said I left a water bottle here ages ago. Someone said. Still? Oh, yeah, there is. Oh,
Still conscious of that stuff. Wait, that sounded like I was talking.
How long's it been there for?
I can't remember actually. A long time.
I think so. Really measure up teas.
Just generally.
And then probably not.
Oh, really?
Probably one day.
You said you're really weak right now.
I am pretty weak. I'm barely eating.
I'm gymming 3 times a week and you still say you
I'm on
smash me.
steroids. You can still be weak.
Really? No, into the thing.
Oh,
Sorry, no,
In
I
and
wasn't
out.
being, that wasn't like a person request. The case is a bit dry. But sometimes IP's interesting. We had the collar that comes together. That was fun. No, the cake, you know, the M&S one.
oh.
Yeah, because I think it was with Lidl or no, Aldi. We've had Aldi quite a few times. We also had a cider one in it. She thought.
One trick here. Is there any spare on your side?
Yeah.
I can do my side.
No, don't do that one. That one's loose. Is it working?
Yes. Does my email look fine?
Oh, wait, let me see. Yeah, it's fine. I mean,
Quite like the use of the term resurrection.
Yes. Seems
Sound like the
appropriate.
second coming of Christ. I refereed last night and I was doing the match. I looked up and saw some shit like Charlie Austin.
Who's he playing for?
Hungerford.
How old is he now?
36, I think.
Oh, is that all?
Sorry, for ignoring you.
Got the same age
That's
as
like about 45.
God, when was he last playing for? 3 or 4 seasons ago.
Yeah. Yeah, 3 years ago. Just over 3.
He can't be doing it for the money, can he?
Yeah, I doubt it.
He loves a game, maybe.
And then
That's
How old is young Jordan Henderson? I took her to a tour, sort of junior, sort of fans forum in Brentford, where they had the chief exec, Keith Andrews' manager, Jordan Henderson, and our captain, Nathan Collins, and quite a lot of the kids, he's 35, were asking about how does such an old man carry on.
switch between free and
You know, what the only kids could get away with.
yeah.
He said, I might be a little bit slow, but my brain's a lot.
Yeah, but I've been on so many different ones.
So I thought it was a
But they
good
all have
answer.
different side effects. Last one I couldn't sleep.
It's a fair old schlep, isn't it? Hungerford.
I was in Brighton,
Oh, okay.
which to be fair, driving out of London took us about just under 2 hours.
Or also take acid blockers.
Mr. Moody Stewart, I now have the benefit of a heater. You are going to be held to your declarations of being fine.
My lady, I'm obliged. The layers of jackets, gowns and horsehair, I think, will
Very
keep me
good.
to-
Yes, thank you very much indeed.
So, my lady, my lords, I'll start, if I may, with some points of common ground between the parties to clear the way. In the light of, I think, my learned friend's submissions at the tail end of his address, it is common ground between us that it is not wrong as a matter of principle for a strikeout in an unjust enrichment case ever to be considered. That's not our position at all. It's our position, of course, that when there is a case that addresses a difficult and a developing area of law, it's important, and I don't understand that this is disputed by my learned friend, it's important that that should not be addressed on assumed facts on a summary basis where there are relevant disputes of fact or relevant disputes as to the context against which that point of law should be considered. And in the light of my learned friend's submissions this morning, both as to the nature of my client's rights and the benefit that he says he obtained, his client may have obtained as a result of the agreements, in my submission there is a very substantial and relevant dispute that goes to the heart of even the single issue that is supposed to be on before the court on this appeal, which is the question of whether a benefit has been taken at my client's expense. There is a dispute that has been thrown into sharp relief by my learned friend's submissions, but was visible on the skeletons, as to the nature of my client's rights, and in particular whether they have a right, as opposed to a mere restrictive covenant in relation to the performer's rights and other rights concerning Mr. Cushing's performance, and whether we still have a right, and we say we do, to make the TV movie. And there's also a dispute as to the nature of the benefit, which was revealed by my learned friend's discussions with the bench, the nature of the benefit that my learned friend's client has obtained from the 2016 agreement and making their own film, Rogue One. So there is, although this appeal is advanced, my learned friend has stepped back from a very broad attack saying our case was hopeless on a number of different grounds, which fell before the master, and then he retrenched somewhat on appeal before Mr. Mitcheson sitting as a deputy, and before your lords and your ladyship now, he has restricted himself to what purports to be a single ground of appeal. Packed up within that are a number of important contextual issues that will require to be resolved in order to be sure that the correct decision is reached, and the venue for that, we say, is at trial.
You're going to tell us what those contextual issues are?
I certainly am, my lady. Sorry, and I'll stop introducing in just a tick. But I can flag it up now, because if I tell you the structure of where I'm going to start by going back to the subject matter of the dispute, the rights in question. So I'll look again at the contracts and say why I say my learned friend is wrong about the nature of our rights, my client's rights under the agreement with Mr. Cushing and binding the estate. And I'll also address you as to why he's wrong about the nature of the benefit that he's obtained. And this is why at some length in my skeleton I go on about primacy, utility and breadth to say this peculiar package of rights, the right to resurrect Mr. Cushing for the first time in a film, is something that was of importance and of value. So that's the key, a key point of contextual matter that needs to be resolved. So that's the first thing that I will go to. Then I will and just to flag up, I mean, the heart of our case is this, that a benefit that I'll explain to you that we obtained has, in effect, vanished, is no longer available to us, this right of primacy to recreate Mr. Cushing's image in a film. And not only is it vanished, it's not available to us, it's been utilised, it has accrued to the appellants. And we say, and it may be simplistic, and I'm sure my learned friend will say it is, but we say that where a benefit, where an asset has vanished from the pocket of one party and appeared in the pocket of another, it's not fanciful to suggest that that is a benefit they have obtained at our expense, whether directly, indirectly, or through a relevantly coordinated series of transactions. So that's the point on the nature of the rights in question and the dispute. Then I will go again, I'm sorry to say, to ITC and perhaps some other authorities and the extracts from, some extracts from Goff and Jones, and explain why, as a matter of law, what the factual circumstances, as we contend them to be, are not excluded from the ambit of unjust enrichment. And that's what we have to show. For the purposes of this, we don't need to show that they are included necessarily, definitively. We merely show that they're not excluded. And I'm selling my case short at this point, but I'm addressing this as an appeal against a refusal to strike out. Then the third point will be, I'll address my learned friend's further supporting arguments, his points on the supposed floodgates, and the suggestion that if this were a good point, it had been raised in various other cases. But that's really to sort of conclude it. But the two key points that I will spend quite some time on within my timetable are to identify our rights and to say why the authorities do not say we're excluded from pursuing a claim such as the one we have advanced. And in doing so, I'll touch upon, I think, some of the questions that my learned friend was asked about. Do coordinated series of transactions have to be prospective or retrospective, and indeed the perspective from which one looks at those. And without giving the game away completely, my submission will be that when one properly considers the nature of the asset that we say has been transferred, then the transactions surrounding which relate to that, it really doesn't matter whether it's looking forward prospectively or respectively. It's looking at it from the wrong perspective entirely. You need to look at it from the point of view of the right that has gone across. And we say there's enough within the nature of that right, albeit that it is founded and then transferred by contracts quite some period apart in time. There's enough, because it's the same asset, there's enough within that to render those transactions relevantly coordinated, or in some other way bring us within the scope of a direct or indirect
So
transfer.
the mere fact that it's the same subject matter is enough to make it coordinated?
Not the mere factor, but that is a key and important factor, and in the circumstances of this case, the way in which the same subject matter attracts is important, and that is enough. So my learned friend spends quite some time saying, criticising the way in which we advance our case by saying that it is analysing at a level of generality that this is just about one contractual right and a party who is owed a contractual right by, say, the estate, in our case, and that is then breached. It's then said that we have a claim against anyone who has benefited from that breach. At that level of generality, of course it sounds absurd. That's not the level of generality at which we pitch it. We say that there are other things that connect it to a particular IP right and bundle of IP rights that make it reasonable in this case that we have such a claim. And if one applied the level of generality, that criticism, to say there are just two contracts, at that level of generality to some of the decided cases, for example, the BFC and Park case, which was to do with contractual claim and subrogation in favour of a party who wasn't bound by that contract, but under the benefit of another contract, could then bring their, rely on their charge, which had been promoted. If you applied at that level of generality, it would also exclude that case. We are not seeking to set out, to crack open the doors of unjust enrichment so that any breach of contract from which a third party benefits will give rise to an unjust enrichment claim. We say we've identified certain specific facts in this case, which we rely on, and when it comes to considering those facts, it must be done in this court on the assumption, moving on to some of the more agreed things between the parties, on the assumption that Malone & Friend doesn't have a bona fide purchase of defence. For the purposes of considering this, it's something that will be live at trial if we get there, and it must be considered on the assumption that there has been a benefit to him and that he needed the permission of the estate to do the things that he did. So there are a number of points that it's not open to my friend to suggest or rely on, as he does in his skeleton somewhat mealy-mouthed. He says, well, it's not clear that the claimant has indeed suffered any loss as a result of this. You know, I think he says, if any, in
Just
relation
pick
to
you up.
loss.
Why do we have to proceed on the basis that there's no bona fide purchase of defence?
Because if we're proceeding on the basis of assumed facts, then it's not before. I mean, those must be assumed in my favour, and so Malone & Friend doesn't.
I don't think that's right at all. I mean, your assertions, you have to proceed on that, but you haven't. I don't think that is an assumption that I'll have to think about this, but I think the premise for this application or the appeal would be that there is an outstanding, arguable, bona fide purchase of defence.
My lady, it's outstanding and arguable.
right.
It's not open to my learned friend, of course. It's not open to my learned friend to say, assume in his favour that he was aware, so that he wasn't aware of what he was
No, I
doing.
understand that, but I think we just have a think about it. But in my own mind, that is an outstanding question, and that's the context for the strikeout. Yeah.
My lady, yes, and I certainly don't intend. I mean, given I'm going to be saying the floodgates aren't cracked open at an early stage by a decision in my favour, it would be odd of me to sort of saw away at the branch between me and the tree by suggesting that my learned friend doesn't have a bona fide, or not even the argument of a bona fide purchaser a defence when it comes through. So it's anyway. So. Having set out the structure of my submissions, rather than continuing and having asked quite properly, my lady, to say, look, what are the factual disputes you say are relevant, it's important, I think, first to turn to the rights in issue and consider what my clients had by way of rights and why there is this dispute, identify the dispute between my learned friend and myself as to the nature of those rights. The rights in each case, actually, sorry, before I go on, I've taken myself on. There's a further point, I would say, of commonality between the parties, which is my learned friend is quite right to say that I have not been able to identify a case in which the facts of the present case, or something that is directly analogous to it, has been successful at trial and held to be amount to unjust enrichment. Similarly, my learned friend has not been able to point to a case that rules against the position my client is adopting and excludes it completely. So this really is a question to be decided by you today as to whether or not it is unarguable that the case my client advances falls within, the potential scope of unjust enrichment, in particular in light of the carefully non-limiting description of unjust enrichment and explanation of unjust enrichment given by Lord Reed in ITC. So with that introduction, I'll turn to the rights in issue. So those are first the benefits granted to my client, and then we'll consider what we say has been transferred to the appellant. They were created by contract in each case, but underpinned by proprietary rights by way of intellectual property rights of Mr. Cushing and later the estate. Now, if we look at my client's right, just to give the context, in August 1993, Mr. Cushing was terminally ill, but wished to continue working, and he engaged via his production company with my client to make a TV film that was to be called Heritage of Horror. My learned friend showed you the agreement, called in these proceedings the TVM agreement, which is at Supplemental Bundle tab 2. But let me just show you how that's, just take you to the pleading and how we set out our case in relation to it. So core bundle tab 6, page 70, under the heading the 1993 agreements. So, paragraph 8, we set out the claimant entered the agreement with Peter Cushing, PCP, dated the 2nd of August 1993, in relation to the Heritage of Horror, in which it was agreed that Mr. Cushing would appear. And then at paragraph 9, we see it was known to both parties to the TVM agreement. Mr. Cushing was at the time terminally ill. As a result, the claimant contemporaneously entered into a further agreement with both PCP and Mr. Cushing, dated the 2nd of August 1993. Now that's the letter agreement which supplements the claimant PCP's rights, and that's the one which contains the clauses that are set out at 10, 11 and 12, but what I'd rather do is take you to the document themselves, look at the letter agreement, which is at Supplemental Bundle tab 3, page 34. So, and although it's clear from the first page, page 34, in the recitals, a fundamental part of this agreement, the point of it, was that both parties were aware at the time of Mr. Cushing's unfortunate illness, and notwithstanding that, they were prepared to go on and attempt to make the film. But that is why and I accept slightly peculiar safeguards involved, were later agreed. Overleaf at 35, we see under the heading clause 8.2 and 8.3. My friend's shown you these already. But E, as a result of the illness, PCP and Mr. Cushing undertake, warrant and agree that in connection with the production, completion, exploitation of the TVM, we may utilise. So this is a grant of rights in connection with the production of the TV movie. And at 7, there's a specific grant of permission to use extracts from other films and or programmes in which Mr. Cushing has previously appeared, subject only to our obtaining the consent of the copyright owners of such films or programmes. So there we have a licence granted of, it would probably be analysed now looking back at what they become as performers' rights, because you've got the copyright. Copyright may well have been owned by Mr. Cushing in some things, but in respect of any other material, Mr. Cushing's performers' rights or image rights or any right goodwill or such rights that would attract to the utilisation of those extracts have been granted by E6 to my client for use in the context of the TV movie. Okay? And this is why in my skeleton I talk about this being both broader and narrower than a licence, because it is a consent to use rights, but it's not limited to specific rights. It's framed very broadly in relation essentially to all of the rights that Mr. Cushing has in his oeuvre, as it were, but only for a specific purpose. So I say breadth, utility. And so this is, again, it's not something akin to a license. If you have a license, a plain license in relation to a specific performer's right, you can use it for whatever purposes. It's not limited to what use you can put it to, and it is, but it's not broader than that particular right. So this is a broader right in the particular circumstances. And then, and this is an important dispute between my learned friend and myself, which will require resolution for my learned friend's case as advanced on appeal today to be decided in my submission, because he put forward his case today on the basis that my clients have no rights now to continue to exploit any intellectual property or other rights of Mr. Cushing or the estate, and they have no right to make their own movie. We say that's not the case. So clause 17, under H, if as a result of the illness, Mr. Cushing's demise or any other reason without limitation whatsoever or howsoever, the TVM is not produced and or completed and or exploited, PCP and Mr. Cushing hereby warrant, undertake and agree that neither of them will permit Mr. Cushing's participation in any film or programme whereby Mr. Cushing appears either in whole or in part other than in person. So he could turn up, so this is before his, if he were still alive, he could have turned up and done this, in or out of character, by way of Mr. Cushing being reproduced by all or any combination of the processes or techniques referred to in paragraphs 1 through 11 of paragraph E hereof, without our express prior written consent, which consent we may grant or withhold at our sole or absolute discretion. Now, two things arising from that. First, we say, and this is a point I've canvassed in my skeleton, this is a right of primacy. We say this allows my clients to, subject to any prior rights which would entitle Mr. Cushing to be reproduced in the way contemplated here, but subject to that, it entitles my clients to be the first to what we call resurrect Mr. Cushing by way of film. Now, the second point...
Sorry, that's clause H, is it? Gives you
That's
that right?
H. That's H.
Where does clause H give you the right to do anything other than to refuse consent?
Well, because, sorry, we say that the rights, we say that then I need to deal with my second point. Sorry, I should have taken them together as it goes. We say that 17, that on its true construction...
17?
Sorry, under H, under 17,
yeah,
on its true construction, means that unless and until the TV movie is made, we have the right of primacy to block anyone else reproducing Mr. Cushing. And when the TV movie is made, then obviously our right of primacy is gone. We no longer have that in place. But it is not, as my learned friend has characterised this clause, it is not the case that this clause, because the TV movie has not been made yet, this clause means that we are no longer the beneficiaries of our rights under clause E to reproduce Mr. Cushing for the purposes of our TV movie. So...
Sorry, I'm just not following at the moment.
Right, sorry, I'm garbling it.
Maybe you're trying to construe E and H together to provide some third outcome. Yeah. But well, H itself doesn't grant any rights, does it, other than the right to refuse consent?
That's H, until the TV movie is made, H provides, it gives us the right to refuse consent.
Well, does it? H is if it's not made.
Well, we say on its true construction, we say if it's not made, but if we make the TV movie, then that right would disappear. We retain the right to make the TV movie.
The right in H only arises if you don't make the film, doesn't it?
Well, the film has not been made, but we still have the right to make the film. We could make the film using Mr. Cushing's image. That's what we say the construction of the underlying agreement and the rights granted under clause 8 and 3 and as further granted under E under that point on 35. So we say that the consequence of H and E together is that we have not only the blocking right in relation to Mr. Cushing's reproduction, we have the right of primacy, we ourselves, could have made and can still make a TV movie,
Sorry,
Heritage of Horror.
Just this is really very important. You have a blocking right, you
Yes.
say, and then you have the right of primacy. What did you then say?
Sorry, the right of, so the blocking right is our right of, it gives us primacy in our right to resurrect Mr. Cushing by way of technical means in making the TV movie. Sorry, my lady, this,
Can I understand this, Mr. Moody? It's part of what you're doing. You say that H is written if the the TVM is not produced,
yes,
PCP and so on. And I think part of what you're submitting is that the way to read the if it is not produced or completed is I'm just putting it in my own terms, is
Until.
while the TVM is not. Is part of what's covered by
My
this.
lord, yes.
It's not just, what you're saying is it's not just something which is triggered after the TV movie is not produced. It also applies while the TV movie is not produced.
my lord, yes.
And so what you're saying is before the TV movie is produced, the combination of E and H means that you have the ability to make sure that the TV movie is the first time Mr. Cushing's likeness appears after his death. That's the point
My
you're
lord,
trying
that's
to
our
make.
case. That's how we interpret the combination of those two clauses and the contract, the production agreement.
So it's not just that what you're submitting is that the interpretation of H is not just that it's a condition that kicks in after the TV movie hasn't been made. It's one that applies while it hasn't been made.
My lord, yes. One could say while, one could say until it is made. It's so, and this has come up now in that for the first time a learned friend has advanced this concern and said that this is how he understood H. As this morning is the first time I've heard it. It was a surprise to us. We are
So what's the surprise?
my learned friend's construction of H. I hadn't contemplated.
Your case, this isn't, I think, pleaded, is it? The construction you seek to draw or arrive at isn't pleaded, is it?
Well, my lord, in our context, it's consistent with our
Well,
with
just
our
show us
pleading.
where it is in the either in the pleading or in your skeleton.
So, my lady, in our skeleton, this is what's behind when we characterise our right of primacy. When I'm saying primacy, utility, and breadth, underpinning that is that my clients have the right first to reproduce Mr. Cushing in the movie. So that's the utility, primacy doing it first, utility in the movie, and the breadth is the number of different rights that are engaged. So this is how we have, in my appeal skeleton, I spent some time talking about primacy, utility, breadth. So my learned friend and I are at cross, whether they're cross purposes or just opposite contentions as to the proper construction of these terms in the agreement.
Whitebell, I saw your skeleton references to primacy, and I wondered where that came from. So that's really what this is about, isn't it? First of all, you're explaining to us the construction argument, but I think we need to see where it's pleaded, don't we, first?
My lord, let me take you to the pleadings. So within the particular claim, I got as far as paragraph 10, and then 14, so the purpose of the claimant's rights under E, H, and I of the letter were twofold. So this is on page 73. First, those rights provided the claimant with a level of protection in respect to the substantial cost and time spent on the TV movie in the event Mr. Cushing was unable to perform his obligations under the TVM agreement. Secondly, in the event of Mr. Cushing's death, the prospect of completing the TVM using visual effects so as to be the first to effectively resurrect Mr. Cushing on screen was a valuable commercial asset expected to attract significant public interest in the event said expectation proved correct. In reliance on those rights, the claimant not only agreed to modify the TVM agreement, but continue to work and expend funds on the TVM. So that's what we say. We had the right. And then in terms of what was the claim against the Fourth and Fifth Defendants and saying that the benefit we say that on page 81 under B, when talking about the enrichment of the Fourth and Fifth Defendants, they were enriched by the matters pleaded above, by being able to do that without seeking, obtaining and paying for the claim's permission if given to reproduce the likeness of Mr. Cushing. So we say that we had the right to resurrect Mr. Cushing, and we didn't understand, and Malone says he said it in open court previously, but certainly it's not been my understanding that it was, and we have only just got to the pleading stage in this case, it wasn't my understanding that there was a significant dispute between us as to whether or not we were still entitled to make the TV movie. So,
Do you agree, do you accept the submission of Mr. Cullen that there's nothing anywhere preventing Mr. Cushing, the company, having previously granted a right of resurrection or immediately after?
we accept previously. If Mr. Cushing had previously granted a right to resurrect, then what he's undertaken is not to give anyone else
Yes.
a right in the meantime.
And nothing to prevent that. What about immediately after?
Immediately after, because we say that H under H is until or while, we say that until we've made the film, he wasn't entitled to give anyone the right to resurrect him.
That's the point I don't see clearly. It's a partial, I mean, you may say it's permitted, but partial rewriting of H to say that the word if means until such time as and thereafter if not made, etc.
My lord, yes.
That isn't pleaded, is it?
My lord,
And is that an argument that's been expressed before?
Well, my lord, it's expressed in our skeleton on this appeal.
I mean that expression, that argument as the construction of H, rather than your
My lord, I'm not sure that I'll check, but I'm not sure it has been canvassed before. I'm not sure it's our approach in the courts below, faced first with the broad attack by Malone and Friend, and then with a slightly narrower approach, has been to say this is not something that should be decided by, at this stage, first by a master, then a judge at first instance. It shouldn't be decided before trial. It shouldn't be decided on a strikeout. Faced now, coming to the Court of Appeal, where there is perhaps, if I can put it this way, a significantly greater likelihood of a tribunal deciding to grasp the nettle and say, well, let's probe and go in and see where we get to. We've articulated our case in more detail, rather than in it's too complicated to decide now, don't it? We've actually gone further in setting out how our case works in our appeal skeleton, perhaps, than we have below. But my lord, I don't accept that there is anything wrong or incorrect or in some way improper in that approach. We've addressed the case as it's been advanced.
Just looking at it may be a suitable moment to break. It's
time flies.
background curiosity. I'm not suggesting this is in any way relevant to the issues that we have to decide. But am I right or wrong that the value, have I seen somewhere the value of your claim against D4 and 5 is just over £200,000?
It's probably a little bit more than that, but it's characterised in two ways.
No, thank you.
My lady, there's the money that was expended in preparation to make the TV movie.
204.
And then there is a value to us in the right. But what is not being put forward, and we have made this pretty clear, it's not being put forward, a suggestion that the value to us of this right is in some way the entirety of the value of making Rogue One or some such.
Sorry, so 204 for the cost. I thought somewhere I'd seen that you confirmed that the only sum being pursued was 204.
There was, in some evidence, I think, on a security costs application, there was a provisional valuation of the claim, or at least that part of the claim, given at, I think, some 234,000 or something like that.
Yes, that's what I've read.
But that's the I can only say that the ballpark without having done that.
But that's the claim for unjust enrichment.
Yeah, that's, well, how, the benefit that my learned friend has obtained by going ahead without our permission, if that were to be valued, because the permission can't be undone, if that were to be valued, one might look at it as saying, well, what would it have cost to get our permission? And so the value to us of the sunk costs of preparing the TV movie and any additional value that we would get for a further matter on top is
And the claim,
but I'm not,
the second defendant has sadly passed, that's correct.
yes,
The claim against D6 is not being pursued.
yes.
So the live claims are against one executor.
I think the claim against the other executor has now been settled.
That's right, settled
we're
for an
down.
undisclosed sum.
It's not public, no, it's an undisclosed sum.
Right. Does credit have to be given for that?
I'd like to think about that. really,
Yes.
but-
And and I've seen
As the
I haven't
agent.
seen the order for payment on account of costs made by Master K, but I have seen the order made for payment on account of costs by the Deputy High Court Judge, 50,000 and a little bit more on account. And what was the order? Has that been satisfied?
Well, yes,
And what about the payment on account ordered by Master K?
I think so. There wasn't, on Master K, I'm not sure that there wasn't a payment on account by Master K.
Oh, but there's an order that there should be a further hearing
Yes.
to that end, but that didn't take place.
Then the appeal. There was an outstanding application to transfer this to IPEC.
Yes.
But, my lady, I would observe, and I'm not sure at whose feet this lies, that here we are, this claim was brought in 2021.
Yes, I've seen
2025.
expressions of the delay. Yes.
And if we had continued without strikeouts, we would have resolved this at trial, and we'd probably be, if necessary, on our way to appeal on the substantive matter
Yep.
by this stage.
That's very helpful, thank you. As I say, I'm not suggesting, and nobody should be concerned, that I'm thinking that any of these matters are relevant. It's just helpful overall context.
My lady, yes.
Thank you very much indeed. Are we still on track if we come back at 2?
My lady, yes.
Very good. Thank you. Thank you all.
Right, okay.
Right.
Yeah, of course.
Yes, let's. There's some sandwiches, I think.